Okay, so should we start with a word of prayer if you want to join me? Dear God, we want to thank you for this time that we can meet together again on a Sabbath to study your word. We would like to ask that you would help us to keep in mind, in our minds strong, the way that you have led us, not just in the recent past or in even this movement's history, but in the whole line of humanity as a whole. Have you led our ancient parents and in all the reform lines and the great controversy, even back to heaven. Help us to learn all that we need at this moment in time where the controversy is coming to an end, at least in this earth context. Now that we're going to study a bit, we pray that you would stay with us and that you would help us to get to know you as much as we can. In the name of Jesus, amen. Okay, so we're going to continue with the study about the presidential immunity court, Supreme Court decision that we had started a couple of Sabbaths ago. And so I want to do some review. And I want to continue, after that, I want to continue reading the court's decision. And I want to make sure we are on the same page as to where we are heading and what we want to do with this decision, which is, I mean, at least now my goal is to be able to take all the cases that all of the actions that were committed by Trump and make an assessment of where we think that falls in terms of presidential immunity, which is what Elder Paminder suggested would be interesting to do in the last study we had. And unfortunately, I haven't had enough time to cover or to get to the end of that. But as I've started to look into the issues, it seems that there's a lot to understand. I mean, at least from the perspective of how US politics work, there's a lot of intricacies and details that, at least to me, that I hadn't been familiar with to an extent that I think would be enough to make an assessment on those things. So I before getting there, I wanted to take some time to keep looking at how the system works and exactly what the court is saying in this case. So we're going to do that. We're going to review, and then we're going to keep reading the court's decision, and we're going to keep commenting on or exploring what they're referencing. Yeah, what they're referencing, and hopefully try to bring some clarity as to what they're saying and how the system is working. So to start with the review, I want to ask if someone can give an overview of what we've been doing. I know it's a complicated subject, so and we are in the midst of a CAM meeting as well. Yeah, just if you remember anything that we had been discussing in that study about this topic. And I'm gonna try to write as we speak. Anybody?
Andreas, I'm really tired after last night, but
Yeah, I
so I
can
can't
imagine.
remember. I can't remember much, but was it? I remember was talking about the external and the internal, something to do with the executive branch and the amount of immunity. I
Okay,
remember
yeah. Maybe
that
maybe
might
I'm
be further down that you maybe don't want to start there.
no, that's fine. Maybe I'm being too vague with my question. I'm gonna say I'm gonna remind us the title was Trump versus USA. Um, and what we were doing is reading at the court decision, which is about presidential immunity. It's with two M's. So we were discussing
Is it
two.
connected?
Yeah. No, go ahead, Emma.
Connected to his role in the January 6th riots, was it?
Yes, yes. So we did like a little timeline of how this case got to the Supreme Court, because the Supreme Court, this was the final, or yeah, at least it was what we were analyzing, how it got to the Supreme Court. And as you were saying, Elder Emma, it came from an indictment from the Department of Justice special counsel that was set up on 4 counts around Trump's involvement in the 2020 elections. So it's four, I'm going to say, yeah, 4 accounts. So 4 things that Trump did are revolving around the 2020 election. And we try to look a little bit about like how this process works in terms of the courts and the judicial system in the US. And we spoke about 2 different kinds of law that there's in the US. Does someone remember what those 2 kinds of laws are?
Are you talking about the unofficial and official acts or not? You're looking for more of a central
Not
law.
at this moment. Yeah, no, it's about something else. But yeah, that's important. That's going to be important. But what I'm asking right now is, this presidential immunity case was around some kind of law, because the other kind of law that there is had been resolved already. I don't know if that rings a bell.
Is it civil and criminal law?
Yeah, civil and criminal. So this case is around criminal law. So I'm going to do criminal and then civil. And this one case is around civil criminal law, because the civil presidential immunity was already established by the Supreme Court in the Watergate scandal time period. And so I had mentioned that first it was a federal grand jury that indicted Trump. Then it came to it. So I'm gonna just write that there's the district courts, and then there's the Court of Appeals, which is called the Circuit Court. And I don't remember if we went into detail as to how this works. But does someone know what a federal grand jury is, so that we can look a little bit more in detail at the timeline? how it happened.
As I can
I've
see,
googled it. I can cheat.
we didn't talk about it, I don't think, Andreas.
Without
According
cheating.
yeah, according to my notes, we didn't talk about it, so I'd have to cheat as well.
Okay. So we didn't talk about it. So a federal grand jury is a group of civil citizens that are called by the judicial system to decide whether a case that's being tried to be handled is good enough, the case is good enough for it to go to trial. So it's normal citizens that are gathered and that are provided with help by the judicial system to make a decision on a certain case.
Do you mean like, is it in the best interest for society? I think Alta Paminda mentioned that once. Might have been in your study actually.
What do you mean? Sorry.
Whether it goes to court is to do with whether it's in the best interest of the community, of society.
I think that's related to the Department of Justice decision to either pursue a case or not.
Yeah, okay, that's it.
Yeah. So I'm gonna be a little clear with this, or try to be clear with this. So first of all, we have the Biden administration here setting up a special counsel. And what that counsel is going to do is going to investigate what Trump did and see if they want to, pursue legal action against him. They did that investigation and they decided that they would want to pursue legal action. So the very first step is to go before a federal grand jury. You can't just take someone to trial directly in this context. You have to pass that first instance where a federal grand jury decides if you can take the person to trial or not. And this is called jury duty in the US. So a group of people, like regular citizens, like if you and I were citizens of the US, we would be in that pool of list of people that could be called to have jury duty. And it's a whole process where people are selected, and the attorneys have the right to see or to decide if the person is biased or not, and they can discard people. So it's a whole process where like a group of people are selected, usually randomly, I mean within that pool of people or of people that are available, and then through a process they get filtered down until the federal jury is composed. And so that federal grand jury decided that it was enough to proceed with a legal trial. So I'm gonna just mark here, this is the concept of jury duty, which is I thought a really interesting concept. I think quite unique to the US, where I think it was designed so that other people, we could be involved in the legal decisions, like citizens can be involved in the legal decisions, judging other fellow citizens, so that it would be more impartial. The whole process would be more impartial because random people would be selected to decide things.
We have that in the UK as well, because my mum has been in the jury twice.
Okay.
Yeah, and you have to go, or you get into big trouble. You can't not say I'm not going.
Yeah, it's mandatory. So this grand jury decided that it could move on. So what's the next step? The district court. And just a quick parentheses that I was kind of like trying to understand for myself. there's the Supreme Court. Oops. And then the country is divided into what's called circuits. So the circuit, it's 12 regions within the US. So I'm gonna say, like, imagine this was the US. You'll have 12 different regions. There's another circuit, I think, that is also part of the story, but to simplify it, there's 12 main circuits, and they are, you know, regions within the US. For example, there's one that's, you know, California, Ohio, Washington State. That's all one whole region. Then you have like states on the East Coast, etc. So the US is divided into 12 regions, and each one of those 12 regions gets one. So each one of those gets only one district court. So I'm going to do this. So this is district court, one district court per circuit. And oh, I'm sorry, I said district, but it's circuit court. Does anyone else know the, like, another name for a circuit court? What does a circuit court do? What's its function? Maybe you can cheat if you want. I would have to cheat too. But this is the Court of Appeals. So each of the regions gets one Court of Appeals, which is kind of like at the second level of a trial. First, it goes to a district court. Then, if you don't like the decision, you have the right to appeal to one of these circuit courts. And then within each of these circuits, there are district courts, which is the trial courts, the ones that actually do the trial. And how many are they? It depends on the region. They're usually divided per state, so it's like one district court per state. But in big states, you can have, like, I think New York has like 4, California the same, something like that. So it's divided into like north, east, south, west. So these are the trial courts, and each of the trial courts, they have so each of the circuit courts, they have a set amount of judges, federal judges, that that handle that court. I think usually it's, you know, in average, I think it's like 11 or 10 or 11 judges per circuit. And then the district court, they also have a number of judges. And I think in total in the US, there's almost 700 judges in total. So in this case, so what happened is the special counsel wants to take Trump to trial. They go to a federal grand jury. So first the investigation, then second step is the grand jury, which is this decision to see if you can go to trial. Then they go to trial in the district court, which in this case was the District of Columbia, so the one in Washington, D.C. And then if you don't like the decision of this, you go to the Court of Appeals. So in this case, the case was called something, I think, like what was it? US versus Trump, if I'm not mistaken. Yeah, United States of America versus Donald Trump. So it's the other way around. So this trial that's going on here is US versus Trump. And that's what, you know, there's four accounts or four things I'm gonna call them, that they want to indict Trump on. So this is the original trial. It never got to a district court, so it never got to trial. And why did it not get to a trial? Anyone knows? So the reason it never got to trial is because when the federal grand jury said that yes, we can proceed with this trial, Trump started another trial. So this is the one that we are looking, I mean, the final decision, which is Trump versus USA. So now it's the other way around. First, it was US going against Trump, and now it's Trump going against USA. And what is Trump's argument in that case?
Are you on about he's saying it's political, or am I thinking?
No, I mean, what is the legal?
Oh yeah.
Yeah, the legal things that Trump is arguing. What? Yeah. What is he going against the USA for?
I'm not sure, but is it like voter fraud or something, tampering with the elections?
No. So in this case,
The votes.
So that's all included. You know, that narrative is all here in the four things that the US indicted Trump for. You know, the elections, everything. But now Trump is only going against the US because he's saying, hey, they want to prosecute me. The government wants to prosecute me for things that I did as president, and I have immunity. So they're trying to go to trial against me, even when I have full immunity to do, you know, whatever I want to do. So the issue of this trial now is immunity. The government is going against me and I have immunity. That's the wrong that they're doing to me. And when it goes to the district court, so it goes to trial, and the district court says, no, you don't actually have immunity. So district court, it says, no, you don't have immunity. Trump appeals, doesn't like the decision, appeals to the circuit court. And the circuit court also says, I agree with the original district court decision that happened in trial, and you don't have immunity. And then Trump takes it to the Supreme Court. And just one fun fact that we had seen is that the Supreme Court, you know, usually the circuit court is in, you know, for like normal citizens, the circuit court, the Court of Appeals, is the final decision, because the Supreme Court has the right to decide what cases are going to take. So like let's say you go to the district court, you don't like the decision, you take it to the circuit court, you don't like it either. You have the right to submit a petition to the Supreme Court, but the Supreme Court is not forced to take that petition. So if they say, no, I'm not looking at that case, that means that the circuit court decision is final. And if they say we are looking at it, then you're lucky, and the Supreme Court, you got another chance of appealing, and this time with the Supreme Court. And usually I think they handle like around 70 or 80 cases. The Supreme Court handles like around 70 or 80 cases per year, which is around, I think, like 1 or 2% of the cases that they receive. So I think they receive like 8,000, something like that, and they only deal with 80. That's how the system works. So it's very hard that it gets to the Supreme Court. It's like around 1%. But usually in cases where it's the federal government is involved, they take it. So it's not just because it's Trump, it's because the federal government is involved in this case. Yeah, so that's the judicial process where the Supreme Court is now making the decision. That's the context. So it went from special counsel. I mean, I'm going to call it case number 1. So case number 1, and this case number 2, which is an appeal to case number 1. So case number 1 goes to special counsel, federal grand jury, and Trump appeals the decision of this grand jury. The district court says, no, you don't have that right. I mean, you don't have immunity. The circuit court says that, and it gets the Supreme Court. Is this clear? I know it's a lot of terminology and it's confusing, but I can try to explain myself better if needed. Or any questions around that, even if it might be clear. Okay, so with that being said, I'll review like an overview of what we saw. We saw that the decision, what was the decision of the Supreme Court around this. So the only question that they were asked is around this case. Like they were not asked about this case. They were asked about Trump versus US. Does the president have immunity, as Trump, is saying? And, if it does, what is the Supreme Court going to do? Is the Supreme Court going to say, yeah, it has full immunity, so this trial cannot, this case number 1 cannot proceed? Or do they have immunity? Do they not have immunity? So yes, go ahead, or some mixed version of that. And the answer is some mixed version of that. So what we had seen is that the Supreme Court is saying there's a role that the president has given by the Constitution, and they're calling it this is all the preclusive, I'm going to call it, and inclusive power of the president. So what did preclusive and inclusive mean? Does someone remember? This is called the outer perimeter of the president's power. Does someone remember what's within this circle? I think we had done something like this. and this was official acts.
And non-official. What was he allowed to do?
Yeah, so this was official and not official. But there's a difference between, you know, official acts within this. So here in this blue area, these are also official acts. What is the difference between these and these? So the preclusive and inclusive, what it means is preclusive. Wait, I have to check because I always confuse the two.
It just says preventing something happening, be it restrictive.
Okay, yeah, that's the restrictive one. So preclusive means the powers that the president has and no one else has. So it's powers that are that only the president can do. So preclusive, only president can do. And inclusive, was the was things that the president can do. So what's included in his role by the Constitution, and preclusive means of those things that are included, what are the things that actually no one else can do? This like not shared power. So for example, one thing can be, you know, if we're talking about the military, and you know, one thing could be something related to the troops that the president can do, but also Congress has certain capacities around that. So there's some roles that are shared, like either the president can do it or Congress can do it. But there's some things that only the president can do, like for example, giving pardons to people. So that would fall within this area here, the things that only the president can do. And this is still something that's official and the president can do, but there's other people that can do it as well. So not official, things that the president does outside of his official capacity, that's clear, you know, like I said, private citizen, etc. So what did they say, the court, what did they say about this area here? You know, if the president does something within the outer perimeter, are they immune? Are they not?
The outer area is not meant, it's not allowed. There's no immunity for that, is there?
Yes, the outer, which is the not official, there's no immunity. How about the inner one, the innermost?
Yeah, so there's immunity. I think that's where the case was complicated because they weren't saying there's full immunity within these circles.
There was an area that's complicated, and that was this one here, the official acts, not within. Yeah. So this area is the complex one, and what they call it is presumptive immunity. And in this area there is full immunity. So what that means is, if the president is doing something within his role, within the things that he only can do, then they have full immunity. And no question. So this is like no questions asked.
Could you give us an example of something that you just said before about, did you say the army or whatever, but can you give us another example of where it can't be questioned?
Yeah, so for example, the thing that was saying about pardons, if the president pardons someone, that's only something that he can do, as mentioned by the Constitution. And what happens is that the motives or the things that motivated the president to pardon cannot be questioned. So you can pardon and no questions asked. One other thing could be related to the conversations that the president has with his officials within the department of the executive branch. So yeah, if he's doing something in his role of president, talking to, I don't know, the vice president, which is something that occurs in this case, that can also be something that only the president
a bit like a state of emergency,
or a state of emergency, or vetoing the resolution from Congress, and that's something that I want to go over. So because that would be the next step, I think, in the study, is going over how the Constitution defines the president and what are the powers of the president. We kind of need to know that in a more detailed way. So yeah, it's a great question, and yeah, hopefully we'll be able to cover that in more detail.
Can I just mention about the border, Andres? The border was an executive order, wasn't it? Like he called it, did he call it a crisis or something? What did he call it? Emergency about the border in the last few days. Was that just him making that, or do you think it was inclusive?
I'm not sure about that one. I'd have to look into that.
Okay.
Calling national emergencies, but yeah. I think the doing an executive order is very likely only something he can do, so it's probably within his role. But that doesn't mean that Congress cannot act and hinder the powers or something. Yeah. So yeah. So what happened with this then, just in reviewing this, is that because the Supreme Court said that Trump in some cases has immunity, in some cases full immunity, in some cases presumptive immunity. I don't know if, does anyone remember what presumptive immunity was?
Have you mentioned it earlier? You mentioned it before, didn't you?
The official acts at the top, isn't it? Is it presumptive immunity?
Yeah. So the acts is the with 4 official acts, they have presumptive immunity. But what does presumptive immunity means? So so immunity means you cannot, no questions asked. And presumptive immunity,
the opposite of that.
The
opposite of no questions asked. Presumptive, because you presume it.
I think it's unofficial acts.
Yeah, so the opposite, I mean, this one's no immunity, but maybe what you're trying to say, Sidri, is that the opposite of no questions asked would be questions asked. So yeah, so yes, they can ask questions. I mean, the presumptive immunity, the way it works is you can potentially take someone to trial for this act. Let's say this was the act that they committed, and they have presumptive immunity. So if you want to take them to trial for this, you can potentially, but there's a high bar that you need to pass, and that high bar is the question that needs to be asked about this particular action, is whether or not taking the person to trial, in this case the president, to trial for that action would put his role as a president at risk, and would make it hard for the president or the next president to be a president and to fulfill their duties. So I'm just going to say this is, I mean, you can take to trial. So potential and but high bar. You have to fully demonstrate that there's no problem, like you're not doing any damage to the office of the president if you're taking it to trial, because, you know, presidents are not going to be scared of fulfilling their role in the future, because, you know, they could be taken to trial. So with this, what happened is that the Supreme Court now says, so the question that was asked to the Supreme Court was, hey, does the president have immunity? And they didn't say no, they didn't say yes. They said, actually, sometimes the president does, and sometimes the president doesn't, and sometimes it's presumptive immunity. So what needs to happen, the Supreme Court says, because like sometimes the types of decisions that the Supreme Court can make is as follows. I have the technical names here. Give me 1 second. So they can affirm, they can reverse or void, or they can remand. Affirm means that they affirm the decision, they agree with the decision the lower court had made. So the appeal, you know, is rejected. Reverse or void is overturn the ruling of the lower court and saying, no, actually they made a mistake, you win the case. And remand is, it means, you know, send the case back to the lower court for trial, after giving them some guidance or clarifying something. So in this case, that's like what happened was a mix of these two decisions. So some of the decisions, I mean, the decision of this lower courts that the president has no immunity at all was reversed. So the Supreme Court said, no, actually they do have immunity in some cases, but I'm gonna send you back, you know, the case, number one case, so that you will need to decide if the acts that the president committed, or what he's being tried for, falls within which circle, number one, number two, or number three. So the Supreme Court will not decide that, but the lower court will have to decide. So if the lower court decides that, oh, hey, actually, yes, this action that the president committed falls within circle number one, that means you can't take them to trial for that. If it falls here, then presumptive immunity. If it falls here, then nope, they don't have immunity. And that's going to be the hard part to determine, because the indictment that the special counsel was making was quite extensive, you know, detailed, of course, and it talks about the actions that the president made. So you have to like go, or the courts have to go step by step, action by action, in order to determine where that action falls. So they have to cross-reference what the president did with what the Constitution and whatever other sources the president's power are defined. So you have to cross-reference the role with what they did and say it's in action in circle number one, circle number two, or circle number three. So there's two components of this study, I think. One of them is around the Supreme Court's decision. And the question asked is, what do we think about the Supreme Court decision? Do we agree with it? So decision. And the second one is, okay, so if we agree with the court's decision, which means that they have immunity in some cases and in some cases not, then the trial, this one trial that, you know, initially started, actually has to happen or can happen. But before it does, we need to determine whether or not the actions within that, you know, case falls in which category. Because if it falls here, then we can't proceed. If it falls here, we have to do a lot of stuff. And if it falls here, we can clearly proceed. So the second part of the study is to go through each one of those four cases against the president and determine where do they fall. So is it number one, number two, or three?
Andrew,
Yeah.
Richard has made a comment in the chat. So if you want to read that.
Yeah. So courts precedent necessitate at least a presumptive immunity from criminal prosecution for a president acts within the outer perimeter of his official responsibilities. Such an immunity is required to safeguard the independence and effective functioning of the executive. Yes. So they're saying they at least need presumptive immunity for the region number one. They ended up given full immunity if it's actually within number one. And then presumptive immunity if it's official but outside of the outer perimeter.
Andreas, where's 3?
3 is no immunity. So
Okay,
yeah, outside of the circle. So
Can I just clarify a question, Andres?
Yeah.
So the SCOTUS decision, what they actually made a decision on was saying that some of those acts do fall into the immunity section, but some don't. But they didn't say which ones.
So they're saying that actually the lower courts has to determine that, but they did offer some guidance as to how to determine where it falls. And it happened that some of them they decided, like, for example, you know, if this is, you know, talking with the vice president and, you know, pushing them to reject the electoral college certification in January 6th, within this, you know, oh wait, actually I'm confusing it here, but so let's say account number 1 was that, you know, it's a long story that, you know, it has, you know, a lot of actions taken by the president, and within those actions they did say, hey, look, for example, this one clearly falls within number 1. So they did kind of like determine a few of them, but not all of them. So the lower courts will have to go through all of them actually, and they will follow, you know, the guidance that the Supreme Court offered for some of the cases. And I mean, for all of the cases, they offered some guidance, but they didn't make a decision whether, you know, I mean, they didn't make a decision about all of the accounts, whether it would be preclusive and inclusive 1, 2, or 3, let's say. Does that make sense?
Yeah, so I was trying to think of an example. So he's allowed to talk to the vice president. Obviously, that comes under an official act of the president, but he's not allowed to go and tell the vice president to do something illegal. So that wouldn't be kind of cast as an official act, is it? Because he's not doing it in an official capacity as president to vice president. He's not allowed to do that, even though he's talking to the president, the vice president.
Yeah, for example, that could be, I don't remember exactly what they said about the president, but yes, I mean, they could say something like that, you know, that you can talk to the president, but the vice president, but, you know, you can't you can't slap them in the face or something like that.
Yeah. Yeah. Okay. So it's quite difficult.
Yeah. Yeah. Yeah, so it's that. And so what I looking at the study overall, what I was saying about the first item of the study, which is, do we agree or not that with this schema of immunity that the Supreme Court is saying, or the decision that they're saying? What I was suggesting is, I kind of do agree because of certain reasons. So one of the reasons, that is that it just makes sense that, for example, if you like, as Parminder, the example Parminder was saying, I think was pretty clear. Like, if you have an enemy of the state and you kill them, killing is illegal. So if you don't take into consideration that they were killing the enemy of the state in that official capacity, someone could take, Barack Obama to court because of killing Saddam Hussein or something like that. So there has to be some level of immunity at least. And it makes sense that immunity, is, if you give the president power to do something, then, or power, and and they only can do that, why will you judge them for doing what you gave them power to do? That's one argument. And the other one is that if you remember, all of this story is about criminal cases. So this is, I would say, like, it's a compare and contrast. So this is criminal, and civil cases were already established. So whether or not you agree that the person can have civil immunity, it was already established in the past. And if I can say that way, nobody complained. So comparing and contrasting. So this was, I think, like 1982 or something like that. So I'm gonna do in the 80s, the Watergate time period, whatever. If it works, within like if it works somehow for civil law, then what the court is saying, actually, it has to work the same for criminal law, and they kind of like demonstrate that. So they're actually doing a compare and contrast that it seems fair to me. So that being said, now the aspect number 2 is what we need to determine now. Like, so this case didn't, I mean, potentially it could have gone to trial because the Supreme Court allowed it. So they said, like, hey, yeah, you can take Trump to trial, but you have to, demonstrate certain things. That could have happened. The reason why it didn't happen was why. Does someone remember why it didn't happen? I don't think I mentioned, but I think Elder Commander did. And Natalie, I think you referenced it.
Shall I not say anything?
Do what?
Shall I not say anything? I've already said what.
Yeah, you can say it.
If I'm right, I think it was to do with it wasn't in the best interest of society.
Yeah, it was. So it wasn't in the best interest of society, and actually the prosecutor, which, if we remember, is the Department of State, Department of Justice, the DOJ. The DOJ is, I mean, it's I'm gonna simplify a lot. It's a set of lawyers that, are within the executive branch, and they just have an internal policy, and they've had it, I don't know for however long time, but a long time. They don't prosecute sitting presidents. So they don't prosecute. No pros. So they don't do that. I mean, someone else can do if they want to. But the DOJ has that policy that, you know, it's not in the best interest of society to prosecute sitting presidents. They might do it after they're presidents. So right when Trump won the elections, the DOJ dropped the case. So that doesn't have anything to do with the Supreme Court's decision. It's just policy of the DOJ, which is within an independent branch of government, which is the executive branch.
Andreas,
Yeah.
was that why I have my memory now and I'm tired this morning? Was that why Trump kept wanting to delay everything till he was president, so the DOJ could just drop it? They knew that they would have to drop it.
Yes, I mean, yeah, he of course wanted wanted to delay it until he was president. Is that fair? It depends on how you look at it, because he actually was right in that he had immunity for certain things. So if you're gonna go to trial against Trump, this trial in its fairness should take, you know, some time, and they actually have to look into whether, you know, the committed, you know, alleged act has immunity or not. So I think,
Yeah.
you know, yeah, was in I think fairly asking for the lower courts to consider, you know, if it has immunity or not. So I wouldn't say, you know, like, oh, Trump was, you know, so it was so dirty of Trump to try to delay it until he was president. He probably,
No,
of course, in his
no, I
interest.
would agree with you. I think also that it was fair, wasn't it, that they took time and stuff. So for one occasion, I'm pro-Trump.
Yeah. So yeah, so that's about the number one aspect of it. And then why, like, I mean, if it's not going to trial, and, you know, if it's not going to trial, why do we want to figure out where we would put each of the accounts? And I think the answer is because we just want to know, like, how Trump, you know, proceeds and the legality of it. Maybe the DOJ department doesn't want to do it right now, but it's interesting to know whether or not Trump, you know, did things in a legal manner or not.
And the whole process of the Supreme Court as well. It's good to know how they work, and yeah, it's very interesting to see what you've drawn about the inner and outer circle and the presumptive
Yeah,
stuff.
but that's kind of like within this decision here. So this all of this logic falls, you know, for this. And then this one here is like, so now that we know, like, sometimes the person has immunity, sometimes they don't, they're not going to be prosecuted because they're a sitting president. Why do we want to know if what they did was legal or not? Yeah, it's because we want to know if it was legal or not, even if, you know, the DOJ is not going to take them to trial for that. Which I think it's kind of, you know, interesting in a way, and this is just my thoughts. You know, I was thinking about this concept that, you know, maybe not always, and, you know, we'll find out when we go through each of these points, but Trump tends to do things legally, which is very interesting, you know, in the context of the Sunday law, I think, because he, even if he's, you know, doing legal stuff, he's bringing up the Sunday law. So how does that work? And, you know, I think to me, it kind of like highlights the fragility of the institutions, and also, you know, the decision of the people of the US, you know, having elected someone to a position that actually, you know, it's very powerful in a way, because, you know, like all this immunity stuff, it's designed to be that way. So you have to be really careful of who you choose when you choose a president. So I thought that was an interesting point, and it kind of like highlights, I think, the responsibility not necessarily of the president in this context, but of the people, choosing someone or giving the power to someone that you know how they act, you know, like they can stretch their, you know, they can do legal things, but at the same time not following the spirit of the law that, you know, that was built. So yeah, I don't know if that makes sense, but I thought that was interesting. Okay, so
People say that I mean, some people have said Trump's stupid in that sense, but he's, you know, he doesn't know much about anything. But it's actually quite clever to be able to do that, to bend the rules as far as you can without breaking them in some ways, and be able to actually know what you're legally entitled to do or not.
Yeah, he's actually really experienced with legal stuff. Like he's known for having gone to court, like even without he was president, like being always involved in trials, and he's got like really smart lawyers. So
that's who's smart, the lawyers. Yeah,
mm-hmm.
Who knows how to win a case.
Well, he's got the finances to have the best, hasn't he?
Yeah. I suppose are you asking the first question, Andrei, SCOTUS decision, what do we think about it? Do we agree with it? Because I think I'm still not sure what they were supposed to be deciding upon. So those two courts decided he was guilty of all these things. And are they now, they're saying, wait a minute, you can't do that because he's got immunity for some of them? Or was the court case over, whether he had immunity or not? Go on. Yeah, sorry.
So we before going to number two, maybe we can clarify number one. So you were saying, okay, you were not sure about what the Supreme Court was deciding. Is that what you said?
Yeah. So I think when you said the first, it went, you know, into the district and the circuit courts, is they were deciding whether he's guilty for these acts, these 4 acts, or were they deciding whether he has immunity for them?
They were deciding whether he has immunity for them.
Okay, so they said he's done this, this, and this, this, and this has happened. Does he have immunity for it or not? So they weren't even arguing about what he's actually done. They're arguing about whether he has immunity. So they said, no, he doesn't have immunity for any of them. And then, so presumably it would have to go back to court after that, because if he doesn't have immunity, now we're going to take him to trial over the things he's done, and we'll win, or we'll get somewhere. So this is a process. Okay, so then goes to the next one. They say, no, he doesn't have immunity for anything. And the Supreme Court say, wait a minute, he does have immunity for some of them.
Exactly.
So they were doing their job doing that in that sense, just deciding what they thought had immunity or what didn't.
Exactly. The lower courts were just saying, as you were saying, you know, like, so they had like a trial was about to start, and Trump says, you know, this trial cannot go forward because I have immunity for, you know, my official roles. Instead of the lower courts saying, okay, you do have immunity for certain things, but we need to actually work it out if you have immunity for all of the accounts that you're charged with. Instead of saying that, they said, no, actually, you don't have any immunity. So this trial will move forward. So the 2 lower courts said that. And then the Supreme Court says, no, actually, they do have immunity sometimes. So you have to look into what he did and decide whether or not it falls within the immunity category. So I think you got it right. I don't know if we're on the same page.
So if Trump hadn't done Trump versus USA, they would have just carried on charging him with the things, not disagreeing over whether he has immunity or not.
If
the case would have looked slightly different, because they would have said, okay, we don't think you've got immunity and we're going to charge you for this, this, and this. But it didn't get to that stage because now they're arguing about immunity.
Exactly. So like this case actually never even started trial. No. So if Trump hadn't, you know, started this one and said like, no, actually I have immunity, don't go forward with the case. If this hadn't happened, then this trial would have happened. So they would have had to determine whether he was guilty or not of the charges.
But you could argue they didn't do the job properly, because they didn't say, because they just blanket statement, all of them don't have immunity, when they should have said this one does and this one doesn't. They should have been a bit more picky.
Exactly.
According to the Supreme Court. Okay.
So what happens when he doesn't get into a second term? Are these cases just closed now then?
When he, like, what happens now that he's elected?
Yeah, supposing if he didn't, I think what I'm saying is, now that he's president, what's happened to these cases? Are they just getting closed? USA
Yeah,
versus Trump. Oh, they just get closed. Right. Okay.
they're getting closed because of this policy that the prosecutors, in this case the DOJ, they don't prosecute sitting presidents. In the future, when he's out, they might,
That's what I was
bring.
asking. Yeah, that's what I was asking. I was going to say, if he doesn't make a second term, what would happen? Would those cases come back and he'd have to face prosecution again? Would he?
Yeah, I think
Oh,
so.
right. Okay.
Mhm. So yeah, I guess I was saying, like, my suggestion was that, yeah, the Supreme Court was doing their job in terms of number one. And I don't know if, like, anyone has another thought or opinion about that. That would be good to hear.
I agree.
I think, yeah, just observation that when we look at the Supreme Court and all their decisions and etc., when they say, yeah, okay, he did have immunity, I think we can often fall into the trap thinking that they're there to defend Trump, that just because they're conservative justices, they're defending him. But actually, they don't really like Trump. They're not friends with Trump. They don't like him, but they are so, to the law, that grounded in originalism, that they're just going to stick to the law, those 6 conservative justices. And sometimes it aligns with things that are in favor of Trump, and sometimes they don't. And sometimes they'll align with things that we like, and sometimes they don't. But yeah, I just wanted to highlight that they're not necessarily friends with Trump or Trumpism.
Yeah. Yeah, and I think one of the other things that I want to do that I haven't been able to do it in a systematic way is, if we, think or agree with the decision of the Supreme Court around this issue, if you look at how the decision was made, it was the conservative judges that, I think it was like a 6-3 decision, something like that. It was the conservative judges that made this decision, and the liberal judges dissented, so they didn't agree with the decision. So the implications of that for us, I think, are quite interesting, in that, in this case, we're agreeing with the conservative judges, and the liberal judges, not only do they disagree, but they're very, strong in their disagreement. And we will read their dissenting opinions. I want to do it at least in the future as well. And I think, like, that, like, the way I'm seeing it, is that, this change of leadership that we had mentioned in the reform lines. So starting, at the Sunday law, prophetically, we mark a change of leadership for the Nethinims, and, instead of their, what we marked as a symbol of AOC, Michael Moore, etc., we now have this movement as a leader. Is because if we kept going with the liberal judges, and if we took, liberal politics as our leader, or as the leader of the Nethinims, they would get some things wrong, or at least that we don't agree with, like in this case. So I don't know if we realize the implications of that. It's quite strong, I think, in my opinion. So
I was distracted then, but you're basically saying in this case you can't really trust the right,
yeah,
the left, sorry, because of their biases.
yeah, And not only that, it's not that we cannot, we cannot trust the right, we cannot always blindly trust the left as well. So it's
Did I
us.
say right? I meant left.
Oh no, yeah. I think you said it. Oh, you said right, yeah. Okay, so you
You
meant left.
corrected it to left. She corrected it.
Yeah. So we kind of like have to trust us, or this movement, God through this movement, which is quite strong. Yeah. Go ahead.
And I think I understand the point you're making, but how can we say whether we're on the side of the left or the right at this point? I know we just kind of said, I think we said, or you said we agreed with the Conservative judges on this case, and they're sending it back. So in their dissent, the Liberal judges are saying, no, we don't think he has immunity on anything. Is that what they're saying?
The dissent, I that's something that I need to look at, because I didn't do it yet. That's
okay. Because personally, I feel I'm not confident to say who's right or wrong yet, unless we know each act and whether we think he should have had immunity or not. So if we think he shouldn't have had any immunity on all those acts, we're going to say, actually, those judges were wrong. He doesn't have any.
Wait, can you repeat that?
So until we were going to go through for the second question, each of the acts that he's done and decide whether he's got immunity for them or not. If we decide, as a movement, that he shouldn't actually have immunity for any of them, then we're on the side of the Liberal judges, aren't we? Saying we agree with the court's decisions before that they were not, and the Conservative judges are wrong to say that he's got immunity on some and not others, if we find he's got no immunity on any of them. So can we make that decision at this point? Because we don't understand the ins and outs of, I don't understand the ins and outs of why the Liberal judges said no.
Yeah, I think you're right. So
Andres?
yeah, go ahead, Curtis.
Correct me if I'm wrong. When Trump brought his case, Trump versus US, and the Supreme Court gave their decision, wasn't the controversy over whether a president does have immunity, full stop? And they came out and said it's up to the courts to filter if something does break that immunity or it doesn't cover immunity. So they weren't necessarily giving a blanket about the different cases. They said it's the courts that need to decide that, need to figure that out. But they were arguing whether Trump does have immunity or not. Not just Trump, the president does have immunity or not. So in their decision, they're not necessarily saying, yeah, he has immunity for these cases. They're just saying that a president has immunity, and now you, lower courts, need to filter what he does and doesn't have. So in principle, like the principle that SCOTUS was saying, I think we could wholeheartedly just agree with that. And then them going and saying, okay, now go and filter it, is where we would go and say, okay, yeah, what does he have immunity with and what doesn't he have immunity with? And when the Liberal justices were saying, no, the executive branch doesn't, their dissent wasn't necessarily about those specific cases. It was just about the principle.
Yeah, so I agree, but I think what Elrema was saying is, we looked at the, conservative judges' opinion, and we said, hey, yes, it makes sense. I think what she's saying is, before, looking at these things, let's actually look at the opinion of the Liberal judges in as much detail as we looked at the opinion of the conservative judges. Because, like this concept that Parminder was saying, like when you have, messengers now and you look at them, at the message, and it seems solid, and then another one comes and they come up with an opposite message and it also looks solid, but it's opposite. So what do we do? So I think she was suggesting that, and correct me, Emma, if I'm wrong, but let's actually postpone this one for a while until we actually get to look at what the Liberal judges are actually saying in detail. Because I imply that they're saying that actually the president doesn't have immunity, but I'm not sure, because it's a long dissent and I've not gone systematically through it as I should have. Is that what you're saying, Emma?
I think so, yeah. I'm saying if I don't know what they're saying, I'm not sure I even know what the Conservatives are saying properly, but if they're saying that he's got immunity on some things, I don't know if the Liberals are saying, no, he's got immunity on other things, or he hasn't got immunity at all, or what their logic is for that. Yeah, I don't know if I can make a decision who's right and who's wrong. It's just because you were saying that in this case we agree with the Conservatives. And I'm like, do we? I'm not sure. I'm not sure I know enough about either one to know.
Yeah. No,
sorry, just miss Curtis's point because I got interrupted. What can you? Sorry, can you just summarize? I don't know if I was saying something different from him or not, because you seem to be saying I'm saying something different. What was your point, Curtis? Was it originally that the Trump versus USA was?
I was just, from what I've understood thus far, I may be wrong, is that the case Trump versus the USA was more about a broad principle
Right.
of does a president have immunity, and where do they have immunity and where don't they have immunity, as opposed to them applying it to specific cases, those four. So they weren't touching on those four. Instead, they said, the courts, that's your job to do, to decide whether that immunity covers this thing or it doesn't cover this thing. But the argument was over a broader principle. Yeah, that's all I was saying.
Yeah, so so I think that's fair to say that we need to actually go first and look at the liberal judge's argument in as much detail as I mean, I feel confident with what I've looked at the conservative judges and what they're saying, but I don't feel confident. I know what the liberal judges actually are saying. So I owe you that. So I'm gonna do that before moving to step number 2.
I could tell you what the Liberal judges said if you want.
Yeah, go ahead.
Oh, I've just got it here. The leading Liberal Justice Sonia Sotomayor outlines hypothetical situations where the concept of immunity could apply. Orders the Navy SEAL Team 6 to assassinate a political rival, she wrote, immune. Organising a military coup to hold onto power, immune. Take a bribe in exchange for pardon, immune. Even if these nightmare scenarios never play out, and I pray they never do, the damage has been done, just as Sotomayor wrote. In every use of official power, the president is now king and above the law.
Yeah, I think we'd need to go in. I think, as Natalie said, a lot of their arguments were based on this could lead to this. And the argument that the conservative justices were saying was, let's just look at the principle, because it's the same arguments that we see with regards to gun control. Is that a principle is being argued, and then the left argues, okay, but this could lead to this could lead to this, and etc., etc. Whereas your originalists are arguing, okay, let's just deal with that principle and see if we agree with the principle. I'm not saying we're originalists or not. I'm just comparing and contrasting that this is the same situation that you have with the gun rights debate.
Yeah, can I comment on that? I think she goes on to say that the core principle, because you mentioned principle, Curtis, the core principle has long prevented our nation from developing into despotism, she said. So I think, yeah, the core principle is important, yeah.
So maybe the issue is that the fact that Trump abuses the principles of the Constitution, which they're saying are in place and are okay. You know, he's got immunity for this, this, and this, but not this and this. But if a president takes that immunity and twists it, then they can actually, and which is what Sotomayor is perhaps saying, that if taken to an extreme, this is what they could do and get away with. No one's done that before because they don't abuse the system, but Trump abuses it and they know that. So that's why they're saying we can't keep this rolling.
Yeah. And is that a fair argument to take away the principle? I guess that's the question. Just like with guns, people can abuse the principle of self-defense, but is that a fair argument to take away the principle of self-defense?
Or would we tackle it by actually progressing the law in some way and not saying that this is we should do away with it, but it hasn't grown like it should have done because they're originalists. They're interpreting it back how it was. Is that why? Perhaps. I don't know.
If you wanted to do that, though, you would say, yes, actually, the president has immunity, as the conservatives are saying. Having said that, let's actually address how immunity works and the details work. But I think the liberals are saying, you know, this whole concept of immunity is not working well.
And those conservatives, in their opinion, I think, as you pointed out, they explained what is covered by immunity and what isn't covered by immunity. So they went pretty thorough in saying, like, Trump can't actually just order someone to go and kill a political rival. I think they were pretty explicit about that.
Yeah, they were.
Okay,
Okay.
Andres, it's nearly 12.
Yeah.
And this goes back to my first point, is that I think we need to remember that the conservative justices are not friends with Trump. So all that they're doing is not because they like Trumpism or like certain policies that evangelicals will push for. It's just they have their own agenda. And sometimes, just like with libertarians, sometimes they agree with things we love and sometimes they harm things we love.
Yeah. Okay, so I think we can we can wrap it up. I think for me, as a summary, I would say, like, at least where I'm at this point is, having looked at what the Supreme Court said, you know, the conservative judges said, it seems very solid in principle, and it makes sense to me, especially compare and contrast it with civil immunity. We would then now have to go through, you know, the definition of the president to determine whether an act that we could come up with or think about falls within immunity or not. So that exercise, I think, is important. And then on the other hand, go through this is something pending, goes through the liberal justices' opinions systematically, because at first sight it does seem that they're just saying, you know, they're giving examples, as Natalie was quoting, and yeah, having read it a little bit, it's giving examples and say, no, if the president does this, they're going to be immune, etc., etc. Actually go through those examples and see if what the conservative judges are saying actually makes the president immune in those examples. And if they do, whether that's right or wrong, like as Curtis was saying, is it a fair argument that they're giving, that just because someone can abuse their power, is it a fair argument to say, like, actually they shouldn't have this power because they can abuse it? Because I think that's the definition of, like, power can be abused, because that's what, you know, power is. But anyway, I think as a summary, it would be that on my side. And the next step would be to go through each of these steps, determine whether or not they're immune according, you know, to the functions of the executive branch, which is kind of like what I wanted to go through, and then go through the examples that the liberal judges are saying, seeing if they're immune actually or not, according to what the conservative judges are saying. I don't know if that makes sense.
Yeah, thank you. Can I ask you to put this is your part 2, is it?
Yeah.
Yeah, when you put it up, so we can keep it all together. Thank you.
Yeah. Okay, so let's close with a word of prayer. Sharing. Dear God, we want to thank you for this Sabbath that we were able to gather together, looking at these this topic that is relevant to us in the sense of our role as students of prophecy and as citizens of this world, as well as to how to see the way society works. We ask that you would give us wisdom, that you would help us to methodologically address these issues and to be able to have a clear understanding of the topic. We pray that you would stay with us during the rest of the Sabbath hours. In the name of Jesus, amen.